Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
So this is session 2 this morning of the Walker Moot Supreme Court in the Torque and Mains courtroom, and court is now in session. We would like to acknowledge that we are speaking to you today from the traditional unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin peoples and all Indigenous peoples in the region of Ottawa, who call the nation capital their home. If you are not located in Ottawa and do not know about the traditional territory on which you are located, we encourage you to navigate to websites like nativeland.ca to find out. And we also encourage that you learn more about decolonization by consulting the TRC calls to action as a starting point. It is with great honor and privilege that I present to you Justice Rosman Medriata from HIROC, Justice Victoria Sistron from BLG, Justice Alex D. Giovanni from Dwella, Justice Kate Deacon from BLG, and Justice Kate Kell from Thomson Rogers, presiding today. So, on October 19th, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health, 13 hours after her transfer from West Valley Memorial Hospital. Mrs. Stark's medical records reveal that she was in perfect health and she had no previous existing medical conditions nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Ms. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5th, Ms. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled. But that same day, Ms. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical resident. Ms. Stark immediately requested Dr. Papadopoulos administer the ivermectin her family physician had prescribed, a course of treatment which he chose to reject. On October 6th, Ms. Stark was moved into the ICU and placed on a nasal cannula during the day and a BiPAP at night. Ms. Stark was treated with the hospital COVID-19's protocol, which consisted of dextromethasone and pure oxygen. On October 7th, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadopoulos. Within 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Lutsier, chose to withhold any further administration and after being informed of Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Ms. Stark's condition worsened and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Lutsier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered in addition to the MAP Plus protocol. In response, Dr. Lutsier asked Dr. Strange to forward him the relevant literature for which he was relying on so that he could make a rational, educated decision, which was provided immediately after Dr. Lutsier determined his time would be better spent attending to his patients than reading what he referred to as propaganda. On October 10th, ICU nurse Delrose Patel was convinced by Ms. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the Frontline COVID-19 Critical Care Alliance MAP Plus protocol. Nurse Patel spoke with the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Miss Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Miss Stark's condition had improved, at this point having only to rely on the nasal cannula. On the morning of October 13th, Miss Stark's family was informed by Nurse Patel that the hospital had misplaced the ivermectin, but there was no need for concern as Miss Stark was making great progress. However, Dr. Luthier once again assumed the care of Miss Stark, and upon learning that the patient's treatment course, chastised Nurse Patel and the medical staff for administering Math Plus protocol. Dr. Luthier then administered remdesivir to Miss Stark. Nurse Patel phoned Miss Stark's family and informed them that Dr. Luthier had assumed care and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of an initiative to help provide critical care to the patients battling COVID-19 in rural communities. At 1:27 a.m., Miss Stark's oxygen level began to drop and she became unstable. Within 3 hours, Miss Stark was again placed on a ventilator. The family arrived at the hospital, but was denied access due to the hospital's COVID-19 protocols in place. Miss Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Luthier, but after 4 unsuccessful phone call attempts, decided to drive down to the defendant's hospital in an attempt to manage the situation in person. Upon her arrival, Dr. Strange was denied access to Miss Stark and was unable to speak with Dr. Luthier. Within 6 hours, Miss Stark's chance of survival had dropped to 20%, and Dr. Luthier informed Miss Stark that he had exhausted both his course of treatment and COVID-19 protocol in treating Miss Stark. Mr. Stark pleaded with Dr. Luthier to administer the Math Plus protocol and offered to sign a release, releasing Dr. Luthier and the hospital and any of its agents and parties acting on its behalf from any and all liability arising from administering the Math Plus protocol to his wife. However, Dr. Luthier refused to administer the Math Plus protocol, and a verbal confrontation ensued outside between Mr. Stark and medical staff, and security removed him from the building. On October 19th, Dr. Luthier agreed to transfer Miss Stark to Falls View Health, where Dr. Strange was on staff and would therefore be able to assume care of her. However, less than 1 hour arriving at Falls View Health, Miss Stark died. In this issue, the questions at In this matter, the questions at issues are the following. Issue A, standard of care. What is requisite standard of care for medical negligence in Canada as correctly applied to this case? Did Dr. Luthier breach the standard of care in A, failing to investigate the literature he was provided with, and B, denying Miss Stark treatment with Math Plus over ivermectin alone? Issue B, causation. Did Dr. Luthier conduct cause or contribute to the harm contribute to the harm or injury Miss Stark sustained? And issue C, vicarious liability. Is the hospital vicariously liable for Dr. Luthier's actions? Justices of the panel, I present to you speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Caleb Borden and Sarah Breakey. And speaking on behalf of the defendant, Dr. Luthier and the West Valley Memorial Hospital, Nick Bola and Sarah Torelli. We are here today to determine the outcome on trial before the court on the matter between Dr. Stark and Dr. Luthier, Mr. Stark, Dr. Luthier and the West Valley Memorial Hospital. Both the plaintiff and defendant's counsel will have 30 minutes each in total, 15 minutes each counsel member to present their arguments to this court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they choose so. I will signal to the court when there are 5 minutes left per speaker. The court now invites counsel for the plaintiff to begin.
Good morning, justices, and may it please the court. My name is Sarah Breakey. With me today is my co-counsel, Caleb Ward. We are here with Borden, Ladner, Gervais, and as said, we will be representing the plaintiff, Mr. Sam Stark, who has brought forward this claim on behalf of his deceased wife. Stark and Luthier is a case of the devastating loss of life. The loss of a wife, mother, lawyer, and powerful businesswoman. An avid biker, non-smoker, and the young age of 29, Miss Stark was the epitome of health. How then did Miss Stark fall victim to COVID-19? How does this young mother with such promising health suffer such incomprehensible misfortune? As stated, Miss Stark was also double vaccinated, proactive in seeking medical help, and supported by her husband, a medical student in his final year at the University of Toronto. What makes this case so tragic is not just another life lost to the pandemic. Rather, the true tragedy comes from the fact that but for the negligent omissions of her hospital physician, Ms. Kyla Stark's death could have been prevented. Today in our submissions, we will explore the facts of the case to determine who is at fault, with the ultimate recommendation that this court finds Dr. Justin Lenczner liable for Ms. Stark's death and Dr. Lenczner's employer, West Valley Memorial Hospital, vicariously liable. In our submissions, I will first walk through the standard of care required of a physician faced with Dr. Lenczner's circumstances. From this standard, I will demonstrate how Dr. Lenczner's acts and omissions constituted a breach of the standard. Next, my co-counsel will demonstrate that causation in this case is made out. That is, that Dr. Lenczner's conduct was causal to Ms. Stark's death and that he is consequently liable in negligence. Finally, my co-counsel will move into the role of West Valley Memorial Hospital to explore vicarious liability. To begin, there are three guiding principles that shape our standard of care analysis: due diligence, timeliness, and informed consent. Ternutson and Korn sets out that the standard of care is that of a prudent and diligent physician faced with the same circumstances in the same field. In other words, physicians, and particularly specialist physicians, are to be judged based on the knowledge that an expert ought to have reasonably possessed. Determining the standard of care of a prudent physician requires medical expert evidence to capture the complexities of medical knowledge. While experts may sometimes disagree in their opinions, variation is acceptable so long as it is, quote, reasonably informed, per Leckie and Chaitin. The depositions of Dr. Titchener, Dr. Strange, and Dr. Moriarty each provide evidence which help illustrate the standard of care. Primarily, both Dr. Titchener and Dr. Strange advocate for a standard that requires decision-making regarding patient treatment to be informed by sound medical science. Ensuring one is informed requires continuous engagement with scientific research and sometimes adapting to new information where necessary. Due diligence is a standard practice across the medical field as it seeks to ensure that patients are being treated with the most up-to-date and effective medicine. It also seeks to evade the influence of ignorance or biased decision-making that could place a patient in harm's way. Secondly, Dr. Moriarty makes several relevant claims related to due diligence that help inform the standard of care. First, physicians have a duty not to harm patients. Second, physicians have a duty to adapt and treat patients with all information available to them. And finally, randomized control trials, or RCTs, are the standard for looking at the efficacy of any given medication. A medication with 5 or more well-designed RCTs will likely fulfill the standard of efficacy. Where physician A, who is in good standing, sends physician B 5 well-designed RCTs, physician B ought to explore those RCTs if they could benefit a patient in critical care. Another consideration in the standard of care relates to timeliness and adequate patient monitoring. Forsberg and Naidu confirms that the standard of care in medicine requires administering treatment in a timely manner, including taking reasonable steps to transfer care to another physician where necessary. Failure to transfer in a timely manner or failure to sufficiently monitor a patient in general amounts to a breach of the standard of care. Dr. Moriarty's deposition echoes this finding. She suggests that when a physician has exhausted all treatment options, transferring their patient to the care of another physician who is competent and believes they can do more is part of the standard of care, failure to do so being a breach. Lastly, informed consent has long been fundamental to medical practice. Leckie sets out a 2-step test for informed consent, fulfillment of which will amount to medical negligence. First, that there was inadequate disclosure of the nature and risks of treatment. And second, that this inadequate disclosure played a causal role in the resulting injuries. Notably, it also must be shown that the patient would not have consented to the treatment if they had been properly informed. Finally, in Millett and Schulman, the court establishes that patients have the right to opt out of treatment or opt for alternate treatment even where doing so entails risk and is, to the physician, a mistake. From this, it is clear the standard of care must encompass the principle of informed consent. If a patient does not consent to treatment, the physician must respect that, regardless of whether or not the physician agrees. This is echoed in West Valley's hospital protocol, the principles of practices and duties of physicians, which emphasizes the importance of collaboration with patients to meet their needs. Given what I have just outlined, we submit that the physician standard of care includes scientifically informed decision-making, transferring patient care in a timely manner where necessary, and fulfilling the requirements of informed consent. With this set out, the next step is to determine whether Dr. Lutzier breached this standard. Here, we argue that he did in fact breach it at every point outlined. Primarily, Dr. Lutzier breached the standard by failing to investigate the resources sent to him by Dr. Strange. After contacting Dr. Lutzier requesting he administer Math Plus protocol, Dr. Strange sent Dr. Lutzier ample scientific resources: 126 studies, 82 peer-reviewed, 64 with results comparing treatment and control groups, all of which evidenced the treatment's efficacy. Dr. Strange also sent this at Dr. Lutzier's request, demonstrating that Dr. Lutzier played an active role in this correspondence. However, despite the evidence sent by Dr. Strange, Dr. Lutzier opted not to investigate the resources, stating that the treatment was akin to horse pills. Neglecting evidence that was clearly worth at least exploring was itself a breach of the standard, since, to quote Dr. Moriarty at paragraphs 48 and 49 of her deposition, good research should not be ignored. Dr. Lutzier's omissions were willfully blind and ultimately meant that he was not making an adequately informed decision in his treatment of Ms. Stark. The fact that Ms. Stark's condition consistently improved in correlation with the Math Plus protocol increases Dr. Lutzier's duty to at least investigate these resources, since doing so is common practice in the field.
Counsel, your friends argue that, and this is at paragraph 25 to about 27 in their factum, they argue that Dr. Lutzier was actually aware and up to date on the research because he was part of the hospital committee for developing COVID protocols. So I was wondering if I could to get your perspective on how the court should address those submissions made by the defendant.
Thank you, Justice. We take the position that Dr. Justin Lutzier was not adequately informed about ivermectin. While he has admitted he reviewed one study prior to the resources sent by Dr. Strange, there is no other evidence of him doing any proper investigation of the treatment itself. Dr. Lutzier has admitted in the record of facts at paragraph 218 of his discovery that he has never been in a position to prescribe ivermectin, nor has he ever studied ivermectin at paragraph 304. While he may have some general awareness, we take the position that he is largely influenced by non-medically grounded biases. Does that answer your question?
It does, thank you.
Okay, great, thank you. So to continue, Dr. Lutzier breached the standard by failing to transfer Ms. Stark in a timely manner. As explained, when Dr. Lutzier stated that he had exhausted all treatment options, Mr. Stark pleaded alongside Dr. Strange to transfer his wife's care into Dr. Strange's care. Instead, Dr. Lutzier neglected this request and left Ms. Stark ventilated and largely unsupported for 6 days. Not 6 hours, not 24 hours, 144 hours of idleness, precious time that other treatment options could have been pursued to save Ms. Stark's life. A prudent, diligent, and ethical physician would have acknowledged his duty to transfer his patient rather than leaving her to die. Dr. Lutzier's omissions can in no way be seen as a timely transfer, and he therefore breached the standard in his failure to exhaust Ms. Stark's treatment options and ultimately her chance of survival. Finally, Dr. Lutzier breached the standard by violating Ms. Stark's right to informed consent. As explained, patients have a right to be involved with their treatment. Dr. Lutzier's hospital employer explicitly codifies this into their protocol. Not only did Mr. Stark plead, not only did both Starks plead that Dr. Lutzier administer the Math Plus protocol, but Ms. Stark was explicitly adamant that she did not want to be treated with remdesivir. Nonetheless, Dr. Lutzier completely neglected his patient's requests, proceeding with the use of remdesivir, which was a fundamental breach of his medical duty. In running through the two-step test from Leckie, Dr. Lutzier's conduct here does amount to medical negligence. Looking to the first step, there is no evidence of Dr. Lutzier disclosing the nature of remdesivir to Ms. Stark. On the contrary, not only did he not fulfill this disclosure, but Ms. Stark clearly maintained she did not want to proceed with this treatment option. This demonstrates that Ms. Stark did not consent to the treatment, nor would she have had Dr. Lutzier fulfilled his duty of disclosure. Regarding the second step, which relates to causation, my co-counsel will explore this component momentarily. But to summarize so far, the standard of care must include due diligence, timely action, and informed consent. These requirements are foundational to the duty of a physician. Dr. Lutzier breached the standard at 3 different points, which is a striking illustration of his negligence and his failure to provide the treatment that Ms. Stark deserved. I will now pass it off to my co-counsel unless the justices have any additional questions.
Good morning. Excuse me. Good morning, justices. The plaintiff's remaining submissions are first, that but for the actions of Dr. Lutzier, Kyla Stark would not have died. And second, that West Valley Memorial Hospital is vicariously liable for the negligence of Dr. Lutzier. The test for causation was laid out by the Supreme Court in Clements and Clements, wherein they held that a plaintiff must show that they would not have suffered their loss but for the negligent act or acts of the defendant. The Ontario Court of Appeal specified the but-for test to medical malpractice in Dyke and Grey Bruce Regional Health Center, where they wrote that causation in medical malpractice cases where the negligence lies in the failure to treat a pre-existing condition requires that the plaintiff show on a balance of probabilities that but for the failure to properly treat the condition, the plaintiff would have had a better medical outcome. A conclusion that but for Dr. Lutzier's failure to properly treat Ms. Stark's condition, she would have had a better medical outcome is supported by the anecdotal evidence, the scientific evidence, and the testimony of expert witnesses. The anecdotal facts of this case support a finding of causation. As spoken earlier about the facts, after being in the hospital for 2 days, Kyla Stark was treated with ivermectin and her condition improved greatly. After the treatment was ceased by Dr. Lutzier, her condition worsened to the point that she had to be intubated and ventilated. 3 days later, when she was again treated with ivermectin, her condition improved to the point where she no longer needed to be ventilated and just needed a nasal cannula. 3 days after that, then having had the information from Dr. Strange for 5 days, Dr. Lutzier again ceased the ivermectin treatment of Kyla Stark. Within hours, Kyla's condition had worsened to the point that her survival chances were 20%. At this point, Dr. Lutzier stated that he had exhausted all treatment options. And despite continued pleading from Kyla's family and doctor, still did not treat with ivermectin, and additionally waited a further 6 days before transferring Kyla to Dr. Strange's care. Shortly thereafter, Kyla Stark died. The progression of Ms. Stark's condition appears to point to ivermectin being an effective treatment. Despite observing this, having access to the literature provided by Dr. Strange, and having, in his own words, exhausted all other options, Dr. Letzier never treated with ivermectin and failed to transfer Kyla in a timely manner. Expert testimony has been considered integral to a court's decision in specialized cases like those involving medical care since Terneuzen and Korn in 1995. More recently, in 2015, the Supreme Court specified that expert opinion is a special category separate from the normally inadmissible opinion evidence. The expert witness for the plaintiff, Dr. Titchener, has had much success treating COVID-19 with ivermectin. On page 124 of the record of fact, he's quoted as saying, "I have never lost a patient when treated with ivermectin. When treating with ivermectin, thousands of patients and not one death or injury." In Cram and Ostreicher, the court affirmed the importance of considering expert witness qualifications when weighing their testimony. Dr. Titchener has had much experience running COVID ICUs all over the world. At the time of testimony, was running the ICU at the Spring Clearwater Hospital in Rochester, and holds certifications and licensure in internal medicine, pulmonary diseases, and critical care medicine.
Counsel, if I could just interject to ask a question. Your friends say that and this is at paragraph 43 of their factum, that had Dr. Litzier reviewed the literature provided by Dr. Strange, his treatment plan would not have changed. Would you concede that if we do make a finding that Dr. Litzier would not have administered the Math Plus protocol and or ivermectin, that causation then is not made out?
Thank you, Justice. Even if Dr. Litzier would not have treated Kyla Stark with ivermectin, having considered the literature, his actions, we submit, still would have caused the outcome. But the negligence is dependent on the fact that he did not do the due diligence of the research, and also that he did not transfer Kyla Stark when he said that he had exhausted all his treatment options.
So just to clarify, your position is that his actions still would have caused or contributed to Ms. Stark's death because he failed to transfer?
Well, also just that his choice of treatment, we submit, would have been a cause, but not necessarily a negligent one.
Okay, thank you.
Thank you. To return to the expert witness testimony, the expert witness for the defendant, Dr. Moriarty, admitted that the research looked convincing, the research sent by Dr. Strange, and in paragraphs 206 to 211 of her testimony, said that she would only need roughly 45 minutes to feel that the scientific research deserved more time to investigate, and that she would only need 3 to 5 hours with the research to feel comfortable administering ivermectin. Dr. Letzier had much more than 3 to 5 hours while treating Kyla Stark, up to 11 days in total after considering the 6 days when he had exhausted treatment. Considering the scientific evidence, Dr. Titchener stated that there have been 64 controlled trials, 32 randomized, and 16 double-blind randomized controlled trials, with meta-analyses finding major impacts on mortality treating COVID-19 with ivermectin. Considering Ms. Stark's exemplary health, vaccination status, and the early intervention possible at her first admittance to the hospital, the evidence leads to the conclusion that she would not have died but for Dr. Letzier's failure to properly treat her condition. Turning to the matter of vicarious liability.
Counsel,
What?
sorry to interrupt you.
Yes.
Before you turn to vicarious liability, I just want to ask you, so reading the facts, I appreciate there was some interference with Dr. Lutzier's chosen treatment. So the fact that ivermectin was given at a couple of points and the math protocol instituted, what do you say about that and the effect that it may or may not have on causation? I mean, it's possible that if she just had been adhered to Dr. Lutzier's treatment that she would have been fine, but there's all this interference. So does that matter?
We submit that the treatment chosen by Dr. Letzier as a supportive treatment rather than an active treatment was not really interfered with by the application of ivermectin, as she continued to be ventilated for portions of it. And in fact, it is admittedly a small sample, but improved each time. And also that he did not start as Kyla's physician at the time. And so his care was not interfered with necessarily.
Okay, thank you, counsel.
Thank you.
And counsel, I have a question also before you move on to vicarious liability.
Certainly.
So your friends argue that Ms. Stark's death was caused by non-negligent causes, that is by COVID-19 itself, and not by the actions of any one physician. So at what point in time, if any, do you concede that it would have been too late for any intervention that would have saved Ms. Stark's life?
Well, according to the research, even at late stage COVID-19, ivermectin is fairly effective at the treatment. It is not as effective as early intervention, but according to the way the stages are laid out in the research, even at the point of the second time that Dr. Letzier ceased the ivermectin treatment, that still would have been considered early intervention according to the research. And even when he transferred her, there's good evidence that ivermectin could still have been effective.
Thank you.
Thank you. Turning back to vicarious liability, in Yepremian and Scarborough General Hospital, the Ontario Court of Appeal held that a hospital is liable for the negligence of a doctor employed by the hospital. Dr. Letzier was an employee of the hospital. At page 108 of the record of fact, there is a physician employment agreement wherein the hospital hereby employs Dr. Justin Letzier. He receives a salary, is subject to duties assigned by the hospital, and cannot perform medical services for patients other than the hospitals without the hospital's permission. We ask that the court award damages to Mr. Stark to approximately $29 million for non-pecuniary damages of Kyla Stark's lost potential earnings as general manager of the Toronto Raptors and pecuniary damages, non-pecuniary damages of $100,000, the maximum to account for the tragedy of a loss of a young spouse. If the justices would like more detail, we go into more detail in the factum. Dr. Letzier owed Kyla Stark a duty of care, one which he breached by not doing his due diligence and research, not giving her the right of informed consent, and not transferring her in a timely manner. West Valley Memorial Hospital should be vicariously liable for their employees' actions. We ask that the court find them both liable in this negligence. Thank you.
The court now invites counsel for the defendants to begin.
I'd like to thank plaintiff counsel for their submission and this court for their time today. My name is Bola, and along with my co-counsel, Sarah Torelli, we are here on behalf of the defendant, Dr. Justin Letzier. The tragedy that led us here today is one that has been felt by far too many families throughout this unprecedented time. There have been upwards of 5 million deaths across the globe since the start of COVID-19. Many that share a similar medical history to that of Miss Kyla Stark, young, healthy, and vaccinated. At the conclusion of our submission this morning, this court will clearly see that the tragic loss of Miss Kyla Stark is the result of her contracting a deadly and ever-evolving virus, leading to the development of fibrotic lung disease, which ultimately led to her death, not as a result of the conduct of Dr. Justin Letzier. My colleague and I will address three main points. Sorry, may I continue?
Yes, sorry.
No worries. I will address the issue of standard of care today, while my colleague will address the issue of causation and vicarious liability. My submission will consist of two key points. First, that the standard of care in this case is that of a reasonable and diligent physician, nothing more and nothing less. And second, that Dr. Letzier complied with his duties and principles of a competent medical professional and aligned himself with his professional code of ethics. The standard of care for medical professionals in Canada has long been established as that of what is accepted of a normal and prudent practitioner of the same experience and standing. Dr. Letzier holds himself out to be a specialist and therefore is required to display the standard of proficiency of an average specialist in his field. The test is not if something better or different could have or should have been done, but if the doctor ultimately failed to breach the standard of the profession. The Supreme Court of Canada in Wilson v. Swanson sets out the test of reasonable care by stating that the test can be no more than whether the decision made was a result of the intelligence professed, or if what was done such that disregarding it may be the exceptional case, but that in all circumstances, if a substantial opinion confirms it, then there is no breach. It is the position of the defendant that Dr. Letzier's choice to administer the supportive care treatment was not only the standard of care at that time, but his decision was based on informed intelligence and scientific knowledge, which was widely accepted by the medical community at large. Moving on to my second point, that Dr. Letzier complied with his duties and principles of a competent medical professional. In medical negligence cases involving parties with special skill or knowledge, expert opinion evidence is necessary to educate and allow the court to draw inferences from the facts. The accepted standard of care in this case, outlined by both expert witnesses, indicate that the accepted standard of care was that of reasonable and diligent and prudent practitioner, each stating by some variation that Dr. Letzier met the standard. Dr. Strange states that the requisite standard of care was not met based on his failure to administer ivermectin in math and failure to read the literature. She further elaborates that the expected standard in this case includes due diligence, where she stated that either he review the material sent or conduct his own investigation to then make an educated and evidence-based decision, which would amount to due diligence. Dr. Lutzier did in fact make an educated and evidence-based decision when making the reasonable choice to administer the approved hospital's COVID-19 protocols. Dr. Lutzier's medical and professional opinion differed from that of Dr. Strange and is in itself not a negligent act or a breach of the standard of care.
Counsel, if I could just interject there, how do you reconcile the fact that 2 other physicians in this hospital had provided ivermectin and the Math Plus protocol? If you're saying that Dr. Lutzier followed hospital policies, but yet two physicians did provide the treatment.
So basically, I would say that, or pardon me, it's our position that the individuals who provided the ivermectin, first of all, were not part of the research team that developed and strengthened the protocols administered by the hospital in which Dr. Lutzier was, and that they may not have been as informed of ivermectin and the different research that was vetted by the team and other regulatory bodies to have an informed decision about the standard of care at that time.
So would it be your position then that those physicians breached the standard of care?
No, it would be the position that they may have had a mistake in judgment at that point.
Thank you.
Thank you. Dr. Lutzier and his research team, as I just alluded to, they updated that COVID-19 protocol on September 20th, 2021, as they have done each month since its development. It is reasonable to conclude that any information available to the medical community regarding treatments for COVID-19 as of that date were digested and vetted by the larger and trusted agencies and the hospital's research team. Defense expert witness Dr. Moriarty reiterates that the requisite standard of care is the administration of supportive care and had been for over a year at the time of questioning. Though Dr. Moriarty also states that she would have read the study sent by Dr. Strange, she reiterates that she thinks it would be strange not to investigate unless the physician already knew about the studies or had enough solid evidence to refute them. In this case, the defendant submits that Dr. Lutzier already had a solid evidence base and previous knowledge about ivermectin and Math Plus protocols. Dr. Lutzier's refusal to read the specific studies contained within the email does not amount to the fact that he did not have the knowledge contained therein. In order to find a breach predicated on that fact, it would need to be found that there was no other platform for Dr. Lutzier to have been informed of like information. Dr. Lutzier complied with his duties and professional code of conduct by doing his due diligence and making an informed, reasonable choice in the course of treating Ms. Stark as any other reasonable and prudent practitioner would have done. He spoke with Dr. Strange. He heard her medical opinion. He gave her the space to have a conversation about the different courses of treatment and fulfilled his duty to consult within the profession. The fact that he ultimately decided against the opinion of another professional is not a breach of the standard of care. Dr. Lutzier believes that had he followed the advice of Dr. Strange, possessing the knowledge he has about the treatment plan she suggested, he would have breached his ethical duty to Ms. Stark to provide the best care he could and not inflict harm or injury to her. He could not, in good conscience, administer a treatment to a patient that he does not believe to be a reliable and trusted course of treatment in the circumstances.
Counsel, pardon me, sorry to interrupt you. I'm just wondering, your plaintiff's counsel spoke on informed consent. Does informed consent require that Dr. Lutzier provide, well, I guess 2 questions. 1, provide information about a treatment that he doesn't necessarily agree will benefit the patient. And then 2, does it require him in any way to provide that treatment?
So the patient autonomy is an important aspect to be considered, of course, and the patient must be reasonably aware of the benefits and risks. Dr. Lutzier relied on the previous, like his medical team as a whole. When Ms. Stark was initially admitted to the hospital, Dr. Papadopoulos assumed care of her. At that point, she had requested ivermectin and math and refused remdesivir. At that point, Dr. Papadopoulos and the medical team would have reasonably informed Ms. Stark of the risks and benefits thereof. So it's our position that that Dr. Lutzier reasonably relied on the team to inform the patient of those aspects. Does that answer your question?
Counsel.
No,
Thank
thank
you.
you. In order to support the finding of a breach of standard of care, the physician must be guilty of such a failure that no other physician with ordinary skill acting with ordinary care would be guilty of in like circumstances. In an unprecedented time, hospitals, physicians, and other medical professionals work under increasing amounts of stress and pressure to act within the confines of their codes of ethics and professional responsibility. Dr. Lutzier acted in a manner consistent with this duty by following the protocols put in place to treat patients with COVID-19. In Ternutson v. Korn, the court stated that the conduct of physicians must be judged in light of the knowledge that ought to have reasonably been possessed at the time of the alleged act of negligence. Dr. Lutzier's medical opinion was reasonable in light of the circumstances. He relied on a research team and the trusted regulatory bodies to thoroughly vet the ongoing studies produced with respect to the differing COVID-19 treatments. To date, ivermectin and math plus protocol is not accepted by the larger medical community, and advisories against the treatment are suggested. Dr. Lutzier administered supportive care to Ms. Stark and many other patients. He followed a practice in the profession that's well established in light of the current circumstance and widely accepted within the profession. For the reasons I have submitted, it is clear that Dr. Lutzier did not breach the standard of care required of him. My colleague will now go on to address the issue of causation and vicarious liability. If there are no further questions, I'll respectfully close my submission. Thank you.
Council, I have one question before we move on.
Go ahead, Justice Strong.
Thank you. Just on the issue of transferring the patient. So my understanding is that your friends are arguing that at one point, Dr. Lutzier decided that there was no other treatment options, and for one full week, there was no kind of active care provided to the patient, and that failure to transfer the patient during this time was a breach of the standard of care. What's your position on that issue?
So it is our position that there's no formal requirement for a doctor to transfer a patient unless they are unable to provide treatment. The duty to refer has been found in circumstances where a doctor is incompetent to give care or is inexperienced. It is our position that Dr. Lutzier was competent and experienced in this case. Additionally, West Valley Memorial and Fallview are both comparable hospitals equipped to treat COVID-19. Though there may have been no steps in the treatment plan of supportive care at that time, it does not mean that the treatment was ceased entirely. Ms. Stark continued to receive supportive care in which Dr. Lutzier believed to be the best course of treatment at that time. Does that answer your question?
Yes, it does. Thank you.
Great, thank you.
Thank you, Council. Your Honors, I will be addressing issues 2 and 3 for you here today. Issue 2 is that of causation, and issue 3 is that of vicarious liability in relation to West Valley Memorial Hospital. I will first deal with the issue of causation fully before turning your attention to vicarious liability. As outlined by Madam Moderator, the question to be answered in the issue of causation is, did Dr. Lutzier's conduct cause or contribute to the harm or injury sustained by Ms. Stark? There are 2 elements of causation that need to be considered in order to answer that question. The first element is whether or not the defendant's breach of the standard of care was the actual cause of the injury suffered. The second element is whether that outcome was reasonably foreseeable to the defendant. To address the issue of causation, I will be making 3 key submissions. First, I will argue that the plaintiff has failed to adduce evidence to support a causal or contributory link between Dr. Lutzier's conduct and Ms. Stark's death. Secondly, I will demonstrate that causes independent of Dr. Lutzier are a more likely cause of Ms. Stark's death. Finally, I will argue that the death of Ms. Stark was not reasonably foreseeable in the mind of Dr. Lutzier. At the culmination of my submissions, this honorable court will be able to see that the tragic death of Miss Stark was in fact due to complications arising from COVID-19, and those complications were not the result of Dr. Lutzier's decision to withhold or discontinue Math Plus or ivermectin alone. I now turn to our first point, which is that there is no evidence to conclude a causal or contributory link between Dr. Lutzier's conduct and Miss Stark's death. The plaintiff must be able to demonstrate that but for the action or inaction of Dr. Lutzier, Miss Stark would not have died. There is no medical evidence before this court showing that withholding or discontinuing Math Plus or ivermectin alone would in itself cause any harm, and certainly not to the degree that Miss Stark suffered. I am mindful that according to the Supreme Court in Snell v. Farrell, the court must approach this analysis with a robust and pragmatic view of the facts as a matter of fairness. This means that inferences can be drawn where it is reasonable to do so. However, in the complete absence of evidence to support this causal or contributory link, we submit that by relying solely on a robust and pragmatic analysis, which is what would be necessary here, the court would be undertaking speculative reasoning, which is cautioned against in the 2016 Supreme Court Canada case, British Columbia v. Fraser Health Authority at paragraph 80. There are two bases upon which this court could potentially draw inferences. It is our submission that reliance on either one of these would be unreasonable and would amount to speculative reasoning. The first basis of evidence that could support drawing an inference between Dr. Lutzier's actions and Miss Stark's death is the temporality between the two. However, as set out in Barber v. Wilson, it is not enough on its own to prove a causal link. This type of connection cannot be relied upon as proof of causation, as it is merely a hypothesis. It has not been tested or deduced through medical evidence. And I would submit that given the fact that there were many other variables and factors in relation to Miss Stark's ongoing treatment, that this would be even more inappropriate to rely on this factor. The second basis of evidence that could support drawing an inference between Dr. Lutzier's actions and Miss Stark's death is the generalized statements adduced by the plaintiff surrounding the alleged effectiveness of Math Plus and ivermectin treatments. I will not reiterate the points my co-counsel has made in relation to the ineffectiveness and unreliability of the studies that the plaintiff is relying on. But if it pleases the court, I can draw your attention to paragraph 68 of my factum, in which I outline circumstances where studies relied on by the plaintiff have been retracted. So I would like to remind the court that the unreliability of those studies is relevant to causation as well. I would also like to caution the court against using the meta-analysis charts the plaintiff has provided to the court. This is a real-time meta-analysis. Therefore, the results presented are not representative of what was available to Dr. Lutzier during the relevant time. This is reflected in the date showing February 15th, 2022 at the top hand corner of the image. Notwithstanding those evidentiary issues, the plaintiff has not shown that these studies would have been relevant to Miss Stark at this specific time. There is no evidence to suggest that the alleged effectiveness would have even been the same in the case of Miss Stark because of the other treatment she was currently undergoing. Dr. Strange was not the doctor of record at the time she was suggesting this treatment. It would not have been up to date on the real-time treatment being administered or the particulars surrounding the health status of Miss Stark. In sum, the plaintiff has failed to establish a causal link between the conduct of Dr. Lutzier and the death of Miss Stark. As such, they have not met the threshold of proving on a balance of probabilities that Miss Stark's death was caused but for the defendant's actions. The Supreme Court of Canada in Gervais reminds us that it is critical this burden be met so defendants are not held liable for injuries that are linked to causes independent of themselves or anyone else. Which brings me to my second submission. A reasonable inference can be made that the interjection of alternative treatments by Dr. Strange to Dr. Lutzier's patient was detrimental to Miss Stark.
Counsel, if I could just interject.
Dr. Lutzier was administering the supportive care protocol. Sorry, go ahead, Justice.
Thank you. Before you move on to your next point, my understanding of your arguments are that you are arguing as the defendant that Miss Stark's death was not caused by negligence, but instead by a non-negligent cause. And my question to you is whether you as the defendant are required, whether there was any burden on you as the defendant to prove that non-negligent cause.
So it is our position that no, it is not our duty to prove that. The defendant must still prove that, but for the actions of their doctor, that the death would not have happened. If this court is prepared to find causation prior to the standard of care as suggested in the case of Armstrong, then it is a court's obligation to rule out any other non-negligent cases or causes prior to. It is my understanding that that approach is only required when the plaintiff is asserting the defendant's action is the only explanation for the harm. And I would submit that's not the case here. The reason I draw attention to reasonable alternative explanations is to highlight the fact that they have not provided sufficient evidence to discount the other likely explanation.
Thank you.
Okay, so just backing up a little bit, a reasonable inference can be made that the interjection of alternative treatments by Dr. Strange to Dr. Lutzie's patient was detrimental to Ms. Stark. Dr. Lutzie was administering the supportive care protocol to Ms. Stark. And as my co-counsel has mentioned, this is the standard of care, no more and no less. As indicated by Dr. Lutzie in his sworn deposition, it is the widely accepted evidence-based standard of care amongst hospitals that deal with COVID-19 patients. This particular treatment protocol was meticulously researched and developed by a team of experts to be the most effective in light of the circumstances. Given the healthy disposition of Ms. Stark, had this course of treatment been rendered fully from the beginning as it was supposed to have been, it is likely she would have had a better chance to fight off the COVID-19 virus that eventually caused her death. This is supported by Dr. Lutzie's experience treating thousands of COVID-19 patients over the course of the entire pandemic, who presented just as Ms. Stark did. Ms. Stark ultimately died of fibrotic lung disease, which is precisely what is being targeted by the supportive care protocol administered by Dr. Lutzie, and in particular, the drug dexamethasone, which is a steroid to help combat the anti-inflammatory properties. Therefore, it is likely the constant interruptions to Dr. Lutzie's course of treatment could have contributed to the development of fibrotic lung disease. Plaintiffs suggest that withholding of ivermectin caused Ms. Stark's death. And in order for that to be true, the plaintiff would have to show that ivermectin would have in fact saved her life. They would need to adduce positive evidence, so it would be improper to infer causation without that positive evidence. To conclude this point, the court cannot be certain which of these medical interventions actually caused the deterioration or death of Ms. Stark. A reasonable inference can be drawn that Ms. Stark would have benefited more from the administration of one constant protocol, which was congruent with the standard of care, and that did not happen here as a result of forces outside of Dr. Lutzie's control.
Counsel, I just have a question on that point and further to your argument that there's no evidence that the alternative treatments worsened the plaintiff's condition. What weight do you say the panel should give to the clinical evidence that the plaintiff improved after administration of the MAF protocol?
So to that point, given the nature of COVID-19 and the devastating effects that it has on the body, it is more likely to assume, and I believe it is a very fair inference to make, that a prolonged course of treatment would have had any effects. So the fact that dexamethasone was given a day and a half prior to the ivermectin begs the question that we don't really know which drug actually had the positive influence.
Thank you.
So to the final point of causation, remoteness, the court in Mustafa v. Cully in Canada concluded that in order to find negligence, the common law requires the damages be foreseeable to a reasonable person in the defendant's position. This case also held that the degree of probability of a specific damage is not so high that a mere possibility of damages arising would be sufficient. Even the plaintiff's witness, Dr. Strange, agrees that medical decisions should be evidence-based. The evidence-based Dr. Lutzie was drawing from when he made his decision to remove and withhold these unsupported protocols was just that. He was operating in accordance with what the evidence supported. Standard care was effective. Math Plus or ivermectin alone were not proven effective. It is illogical that Dr. Lutze would have reasonably foreseen the consequences of his actions to be detrimental to his patient. And further, given that the proposed treatment protocol had not been proven to be effective, we would submit that it is illogical that any other physician in Dr. Lutze's position would have believed that stopping an unsupported treatment in favor of a supportive treatment would have been harmful. There is nothing to suggest that Ms. Stark was presenting as a patient without ordinary fortitude that would make supportive care protocol inadequate for her. In summary, Your Honors, we submit the plaintiff has failed to prove on a balance of probabilities that but for the actions of Dr. Lutze, Ms. Stark would have died. We know Ms. Stark's tragic death was caused by complications arising from COVID-19, and it's clear Dr. Lutze attempted to provide her with the best evidence-based treatment that he could. There is no direct evidence to suggest the actions by him caused or contributed to Ms. Stark's death. It is quite possible that the interventions of others caused this harm. In any event, it would be improper to hold Dr. Lutze liable for the consequences of actions taken by others when he himself was meeting the standard of care required of him. Further, they have not satisfied the remoteness requirement because it is unlikely Dr. Lutze or any other physician in his position would have would have believed the withholding or retraction of an unsound treatment in favor of an acceptable treatment would cause harm. For these reasons, we submit that causation has not been made out by the plaintiff, and the claim must fail on this ground. If the court does find that evidence is evenly balanced and equally consistent with negligence or no negligence, the plaintiff has failed to meet this burden, and the plaintiff's claim must be dismissed on this ground as well. This brings me to issue 3 of vicarious liability, and quite simply, it is our submission that the case for negligence against Dr. Lutze has not been made out, and as such, West Valley Memorial Hospital cannot be held vicariously liable. We request this action be dismissed with costs, and subject to any questions this court may have, these are the respectful submissions of defense counsel.
Counsel, if we do find that Dr. Lutze is negligent, then what would be your position on the vicarious liability of the hospital in that case?
It would be our position that Dr. Lutze has still not breached the standard of care, and the hospital would not be held liable because negligence would not be made out.
Sorry, my question was if this court makes a finding that Dr. Lutze is negligent, then what is your position on whether the hospital would be vicariously liable for his negligence?
Yes, if he is found negligent, we would concede that the hospital would be vicariously liable through the employment contract.
Thank you.
The court now invites counsel for the plaintiff to begin their 3-minute optional rebuttal.
Thank you. We have three points of rebuttal. One, to our friend's comments on the informed consent. Explicitly in the record of fact, in the deposition of Mr. Stark at paragraph 89, Kyla, he said that Kyla had explicitly said no to remdesivir, and at paragraph 87 said that Ms. Stark had told Mr. Stark that no one was listening to her. We believe that we submit that this is a clear indication that her informed consent was not fulfilled. My friends assert that the expert witnesses, by some variation, stated that the standard of care was as they described. While we can be unsure what they mean by some variation, in the record of fact, Dr. Titchener explicitly said that Dr. Lutze failed to meet the standard of care. And Dr. Moriarty described the situation of Dr. Lutze, also stated, to quote directly from the record, If a physician had the links and the PDF files for both of these resources, and they chose not to read them, or at most scan through a few pages quickly, would that be a breach of the standard of care? Dr. Moriarty, I think it would be.
Counsel, sorry to
Yes.
interrupt you there. I just have a question. So if my understanding is that your friends are arguing that the defendant physician may not have read exactly what Dr. Strange sent, but that he was aware of that literature from other studies and other research he had done. So he had that sufficient knowledge of invectormentin. I'm not saying that right, but you know what I mean. So if we accept that the defendant physician had that knowledge base and was aware of those studies, so the issue of him not reading it directly from Dr. Strange is not an issue, how do you establish a breach of the standard of care?
Well, in the record of fact, Dr. Litzier is quoted directly as stating that he had only looked at one study specifically before this case, and that he had not been in the position to prescribe ivermectin before that. So we submit that the defense is incorrect in their assertion that he had this evidentiary knowledge. I believe I am out of time, so I will leave my remaining point. Thank you.
This concludes the matter of Stark and Lutzier.